Well, hello there, AP Gov. Guess what? We might actually finish chapter 14 in this one. Oh, how exciting would that be? Okay, so this is the last part of chapter 14. And well, I have a couple of slides on additional First Amendment freedoms, and then we're going through all the rest of the amendments at like lightning speed. So, to start, of course, we've already talked mostly about freedom of religion and freedom of speech. I don't know if you can hear my dog right now, but she was taking a nap until I decided to start talking to nobody. And now she decided she wants to be awake. So, anyway, freedom of the press, as we know, and we saw in New York Times v. US, freedom of the press usually is upheld in very, very broad manners, but they are not completely immune to rulings against them. So, we talked about in terms of New York Times versus US, Nixon tried to argue that the release of the Pentagon Papers should not happen because it would be detrimental to national security. Of course, the Supreme Court said, no, that's actually not true because these are things that had already happened. So we know that probably if that were like immediate concern of something that was going to happen, the court probably would have ruled differently. But in additional ways, press can be held accountable. They can be jailed for refusing to answer a subpoena, refusing to give up sources, etc. This is always an issue for media because they really rely on people who are unnamed sources. Because you can imagine somebody in the White House who wants to keep their job is not going to, out the president in any sort of way in terms of policy that they're not supposed to say. So they'll say, yes, you can quote me, but you'll have to quote me as a senior White House official. And then if that ever goes to court, a judge can try to compel the reporter to give up their sources. If they refuse, they can put them in jail. And they can put them in jail for contempt of court. The thing with the media and freedom of the press, I do think that we'll see some interesting cases in the next few years. Like the media, when the Constitution was written, consisted of, like small newspapers, pamphlets, that sort of thing. So the fact that now we have, broadcast media in terms of radio and television, and of course the internet, where like anybody can be a reporter, it really lends itself to, a need for a definition of who is the press and who can be held accountable for broadcasting information that is correct or is not correct. And you think about, go back to that, like the bias media chart that we did forever ago, where you kind of like put different media outlets in different places on the graph. And, if I just like throw a blog up and say whatever the heck I want and present it as fact, am I now a member of the press? And so that is a little bit, not a little bit, a lot of a gray area. The FCC, which is the Federal Communications Commission, was created as a bureaucratic agency to kind of oversee the media. They set decency standards for what you can and can't say on the air, and issue fines and whatnot. And then the internet is largely unregulated, and I do sort of wonder if that's going to stay that way. Freedom of assembly. Boy, this is one that's been in the news pretty recently, huh? So there are what we call time, place, and manner regulations. You are supposed to abide by city regulations when you do, if you're going to put together a protest, or I think about like the women's marches and that sort of thing. Like literally, like permits were pulled in order to, take over streets. And if you do what's called civil disobedience, which is like you are willfully ignoring laws, then technically your right to protest or your right to assemble is not protected. And you can still do it, but you can be taken to jail for it. So recently, of course, we had the protests of the governors more restricted stay-at-home order. This happened, if you recall, after we were already on the stay-at-home order, I think, for a couple of weeks, and the governor said, okay, now big box stores have to close down sections of their store that are not dedicated to sustaining life. So like Meijer was supposed to close their furniture and gardening section and all that kind of stuff, and really just leave the grocery area open. And the idea behind that, of course, was to keep people from lingering in the store who were just happy to be out of their house for a change. And, just kind of, and limit the amount of people that actually had to continue to show up to work and help people. So, and then of course, like the boating, and the golfing and all of that kind of stuff. And people were very upset by that, to the point where they were literally comparing our governor to Hitler, which is of course incredibly irresponsible, because Hitler was in large part responsible for the mass execution of millions of Jewish people during World War II and before. So that is a really irresponsible comparison. Like, you might not like the fact that you can't vote, but to compare somebody to Hitler is just really disgusting. And they didn't even spell her name right. So, but that was technically protected. Now, we lifted those restrictions. I say we, the governors lifted those restrictions. But now there is a public mask wearing regulation. And so had this protest happened, like today, I believe that the city of Lansing could arrest all of these people who were within 6 feet of each other in a public place not wearing a mask. So, that is kind of the interesting part of it, is like, sure, you can get together and protest all you want, because that's your First Amendment right to freely assemble. However, you have to do it within the constraints of the law. And at that point, when they did that, there was certainly, we were saying you can't be within 6 feet of each other, but there wasn't, and it wasn't necessarily the law. The only thing that I am surprised about that they didn't stop is that there was a regulation with respect to gathering in groups. So I'm a little surprised, but I also believe the governor probably said to the police, don't stop it, because you would really have a pretty strong First Amendment argument if the police were to have broken up this protest. Now, should those people have, continued to protest if they are upset about it? Sure. Should they probably have stayed in their cars? Also, yes. Okay, so that was the end of the First Amendment. Now, beyond the First Amendment, because believe it or not, there's more than one. All right, the Second Amendment we talked about, I believe, thought we did, with McDonald versus Chicago, which incorporated the Second Amendment into the states. We talked about that in the earlier one. So the Third Amendment has not been tried by itself at the high court level. So I'm skipping to the Fourth Amendment. Fourth Amendment states essentially that a search warrant needs to be, well, it doesn't state anything about search warrants, but it says that your people are protected from unreasonable searches and seizures. So what that means now is that if law enforcement wants to search your property, they need a warrant. And that warrant needs to be issued from a judge, and it needs to be based on probable cause. Probable cause meaning that, literally, we really truly believe, based on pretty good evidence, that there is something that this person is hiding, and we need to go find it. The warrants must specify, the places they're going to search and the things they're going to look for. And this exclusionary rule ties into the specification of places and things. So in a case called Matt versus Ohio, which is 1961, so it's such an interesting case because the lady, it was Dolree Mapp, Dolree, Dollree, that was her first name. So it was her home. that ended up being searched. So they were looking for a fugitive. The state of Ohio law enforcement was looking for a fugitive, and so they had a warrant to search her house. But the warrant really was only for things that would indicate that this person had been there, right? And I don't know if it was drugs or guns or what they were looking for. But while they were there, they actually found Dollary Matt's stash of pornography. And there was local regulations against having pornography back in 1961 in Ohio. And so they seized that and then ended up arresting Dollary Matt for having pornography. And she's like, whoa, wait a second. That's not what you were looking for. And so you can't just like have this warrant that says that you're looking for this guy who's a fugitive and his guns or his drugs or whatever. And then you find my stuff that you didn't even know you were looking for. And then you're going to arrest me for that? I don't think so. And so Matt versus Ohio, actually Dollary Matt won this case. And so that like the Fourth Amendment had to be like it was even more narrow in this like specification of what can be seized and what can't be based on the warrant. So this idea, like I said, the exclusionary rule is that any evidence gathered in an unlawful search would be excluded. And so the evidence that they gathered against Dollary Matt that they didn't even know they were looking for was, went into establishing this exclusionary rule. So that was an interesting thing. So like if the police think that you are responsible for running drugs, okay, so they know that you are a popular. So they come to your house with a search warrant that says they're looking for marijuana and probably money, possibly weapons, right? So they would specify all of that. But then they also find, a knife that is a murder weapon in a different case that they were looking for. That is actually excluded evidence. They can go back and get another warrant, but they really can't necessarily say, we want a warrant for a knife that was used in a murder because we found a knife that was used in the murder. So you can't use the fact that you found it in a search to go back and get a warrant for it, which is a very odd application of that law. But you can certainly find some other ways around that. And I really wish we were in class because I feel like Eli would give a very good explanation of this because of his work with the Explorer program. I think we've talked about it a little bit earlier in the year too. All right. So anyway, this whole idea of needing a search warrant is limited a little bit too. So police can conduct a search without a warrant if the officer believes that his safety is at risk. If the person consents to a search and is not coerced, so if you get pulled over and cop says, can I search your trunk? And you're not Jay-Z and you don't say, and I know my rights, so you're going to need a warrant for that, which she does say in 99 Problems, which I'm not going to say the rest of it, it's inappropriate. But if you say, yeah, that's fine, you can search my trunk, and like you forget that you have something in there that you're not supposed to, then they can take that because you gave them permission to do so. There's also this idea of stop and frisk, which has been upheld and not in different instances. It really, basically stop and frisk is like a police officer can just stop you and like is allowed to pat you down for, appearing to be suspicious. The problem is that it ended up being pretty racist in its actual application. And so like different courts have, like it's worked its way through the court system at different levels in different states. And again, it's been upheld in some and not in others. And then the other time that they don't need a probable cause or a search warrant, they just need reasonable suspicion is at school. So like if, the drug dogs come through, right, and the dog stops at a locker and starts going crazy, that's reasonable suspicion. So they could open the locker, ask Mr. Farrington to open the locker and search your stuff, and they do not need a warrant for that. Fifth Amendment includes due process. the right to not incriminate yourself on double jeopardy, and property rights. So due process we'll talk about in a second. Of course, self-incrimination is your, quote, right to remain silent. Double jeopardy is you can be tried twice in the same court for the same crime. And then property rights is in the eminent domain aspect. All right, due process. What that means is that there are established rules and regulations that restrain government officials. So there are rules that law enforcement and government, like in the judiciary, have to follow in order to, like, they can't just, come up and arrest you and not tell you why. That's habeas corpus. And then, just like the procedures by which they have to do things, and the laws have to be fair in and of themselves. So essentially, this idea of due process, it's in both the Fifth and the 14th Amendment. It says nobody can be deprived of life, liberty, or property, that's LLP, life, liberty, property, without due process of law. In the Fifth Amendment, it pertains to the federal government, and the 14th pertains to states. It says no state can deprive somebody of life, liberty, or property without due process of law. That clause in the 14th, remember, is what has been used to incorporate civil liberties to the states. All right, there's two types of due process. First is what's called procedural due process. So that means the government has to proceed by proper procedures. So procedural due process means you have to follow the procedures set in place. So here are the rules by which you need to do things, and this is what we're going to have to follow. That's procedural due process, okay? And it limits how the government can exercise their power. So like if the law says you have to do X, Y, and Z before you arrest somebody, you have to do X, Y, and Z. You can't do it a different way. The other one is called substantive due process. And what substantive would apply is that the substance of the laws must be fair and reasonable, meaning the way that the laws are written have to be written in a fair and reasonable way. So they can't be overly discriminatory. The government has to act reasonably when they are creating laws and passing laws, and it limits, again, actions of the government in terms of law making. And this becomes really important, when we talk about like civil rights legislation and that sort of thing. So if Congress were to pass a law that says, like women can no longer drive. Okay. First of all, no. But second of all, that would be a violation of substantive due process because that would not be a fair and reasonable law. And when we get to like classifications, when we talk about civil rights, we'll talk about substantive due process a little bit more. All right. So the Fifth Amendment, which is, that would be my timer. My apologies. Of course, I have to get on my Zoom office hours right now because I'm doing this at 10 a.m. But my iPad's died, which is fantastic. So anyway, Miranda versus Arizona, which was in 1966, and I'm sure you've heard of this case. It's a very, very, very famous landmark case. I am 100% surprised that it is not one of our 15 cases, but it might just not be because most everybody knows about it before they get here. But so Ernesto Miranda was the subject of this case, and the reason why these are called Miranda rights, and this is like if you watch any cop show, like you have to read them in Miranda rights. You have the right to remain silent. Anything you say can and will be used against you in the court of law. If you cannot afford an attorney, one will be appointed for you. Like those are the rights that you're read if you are ever arrested. And I only know that because, again, I watch a lot of law shows, not because I've ever been arrested. But the reason why we have those and why they're called Miranda rights is because it was fought in this case, Miranda versus Arizona, in which the procedures by which this guy was arrested and detained were not fair. So this idea of the right to remain silent, that invokes your Fifth Amendment right, where you cannot be forced to incriminate yourself. And then again, it says the burden of proof is on the government, meaning like they have to prove the case against you. You don't have to prove you're innocent. They have to prove that you're guilty. Okay. And then also double jeopardy is in the Fifth Amendment, which we talked about. So no person shall be subject for the same offense to be twice put in jeopardy of life or limb. This means that you cannot be tried twice in the same court for the same crime. So again, does not prevent state and federal charges, does not prevent civil suits being filed. So remember, well, you guys won't remember, but maybe you've heard about the O.J. Simpson case. Hold on, my dog's about to maybe go bonkers. If she does, I'm going to stop this. So like he was found innocent or not guilty in a criminal trial, but was forced to pay a lot of penalties in a civil suit. So double jeopardy does not count because in civil suits, you're not, like your liberty is not at stake, just your money. Hold on a second. All right. Sorry, I'm back. No, my dog has decided to calm down a little bit for the time being. Okay. So this doesn't necessarily also prevent the appeals process, this idea of double jeopardy. So you can appeal a conviction. And so like then you would technically be tried again for that, but it would be through the Court of Appeals rather than the district court level. Fifth Amendment property rights. Of course, we talk about property in terms of like, no person can, or the government cannot deny somebody life, liberty, or property. Like property was a huge deal, this idea of private property at the time of the founding. And of course it still is now. But the founders thought it's so important that they didn't just put it in that clause of, the due process clause, but it also talked about eminent domain. So this says, the eminent domain clause says that the government cannot take private property for public use without just compensation. So really the founders' intent on that was the government can't come take your land. But the way that that's been implemented has been the government can actually come take your land. They just have to pay you for it. And again, just compensation, which we've talked about, is what a willing buyer would pay in cash to a willing seller. Not in cash. I mean, I'm going to hand you $500,000 in cash, probably not. But basically, it's that like if the government decided that they needed to build a highway through my neighborhood, and they said to everybody, we're going to pay you whatever market value is for your house, then people would, and they'd probably actually end up having to pay a little bit slightly over market value, but people would have to kind of take that. So I can't be the lone holdout and be like, well, that's fine, but you need to pay, like my house is worth, say, $300,000. You have to pay me $3 million for it. Like that's ridiculous. So they can kind of force you out of that if you're being unreasonable. So they get around this idea because of public use, right? So they're like, well, it's in the public interest to build this highway, so get out of your house. And then also there's this idea of regulatory takings, and it's a way for the government to take your property without actually taking your property. And what they'll do is rezone you. So they'll take private land and they'll rezone it for commercial, right? So like if my neighborhood is now rezoned for commercial, that's a regulatory taking because they've made it such that like now I'm sort of violating the law, which is an interesting thing too, because you think about ex post facto laws, but whatever. All right. Sixth Amendment talks about your rights in trial, right to be accused in criminal cases. So Gideon versus Wainwright, we already talked about, that incorporated the Sixth Amendment to the states, but like part of it. So Gideon actually only incorporated your right to an attorney in criminal cases in state court. It did not incorporate the idea of your indictment by a grand jury, which, and again, remember, a grand jury meets initially, like before the case even begins. And the grand jury is the one that decides whether there's even enough evidence to proceed with a trial. And not every case gets a grand jury. In federal cases, like federal criminal cases, you're guaranteed. In state cases, you are not. That part of the Sixth Amendment has not been incorporated to the state. So, but like grand juries will come together and you'll decide, several cases, in one sitting. So you'll go through maybe 20 cases to decide this has enough evidence, this one does, this one does, this one does. A grand jury, remember, does not decide your conviction. That's a petite jury. Your right to a speedy and public trial. So it gives you a right to an attorney again. That's guaranteed into the state now by Gideon. You can take a plea if you're offered that, meaning a plea bargain is just pleading down to a lower offense. And it's done for various reasons. Number one, to, save some room on the docket in court. Number two, like maybe you're offered a plea deal because you're part of like a larger crime ring. And so you're offered that deal in order to give up, your boss or somebody else in there, or a whole bunch of different reasons. Or honestly, the state just doesn't think they're going to win at trial. And so they offer something because they know you're guilty or they suspect that you are, but they don't think they're actually going to get a jury to convict you. So they might offer a plea bargain there. You're guaranteed an impartial jury of your peers. And again, like I said, a petite jury is the one that actually decides guilt or innocence. So like if you get called for jury duty, it's usually that. Unless you're called in federal court, then you could be called as a grand jury. But anytime, like if you're called to state court in Port Huron to do jury duty, you'll be on a petite jury. And oops, sorry about that. Sentencing has to be fair. So, like no cruel and unusual punishment we talked about before, no excessive bail or fines. It's guaranteed by the Eighth Amendment. And you are guaranteed an appeal as well. Seventh Amendment talks about suits of common law. It says in cases over $20, which is interesting because if you were to rewrite that today, I'm not sure that it would still say $20. I'm sure it would be a little bit higher, but who knows? So that's talking about civil trials. The Seventh Amendment is not incorporated to the states, as we've talked about. So if you get sued in state court, or you are suing somebody in state court, you are not guaranteed a jury. So you're more likely to just go in front of a judge. Oftentimes, if the person who is doing the suing, so the plaintiff in that case, often if they request a jury, they'll be given that. And oftentimes if a defendant requests it, they will not be given it. But so you are not necessarily guaranteed that. Typically, like if you think about, like if somebody is suing like a doctor for medical malpractice, right? They are going to want a jury trial in that suit because odds are, if you have a jury of your peers, again, I'm doing my air quotes, you can't see them. But if you're a jury of your peers, you're pretty likely to have somebody who believes that at some point, some doctor either messed something up for them or charged too much money or whatever, right? They have a beef with the healthcare system in some way, shape, or form. And so a lot of people, when they're suing these doctors or corporations or whatever, they want a jury because they think that they'll be able to capture the emotion of a jury that would say like, yeah, you know what? I've been wronged too. And so this person deserves that. Where a judge might be a little bit less likely to be emotionally attached in that instance. And a judge is, obviously like a trained lawyer and is in that position is in that position to, because they're very impartial and they're very good at what they do, and they keep their emotions out of it. All right, I'm going to have to pause this for 1 second again. My apologies. I'll be right back. All right, I apologize again for that. I mean, it's on delay on your end. Just don't hear me for a second. But all right, so that's the 7th Amendment. 8th Amendment is no cruel and unusual punishment. So there's a couple of instances though where you're like, gosh, how is that not cruel and unusual, right? But so this idea of this 3 strikes and you're out policy, right? So if you get convicted of the same crime, it's usually a violent crime, 3 times, then you're just sentenced to a greater amount, possibly life, possibly, just 25 years, whatever. Like, you're given the highest sentence for that crime automatically on your 3rd strike. That's been upheld as constitutional. It's not implemented in all cases, certainly, but judges are allowed to. And then a subject of an argument of cruel and unusual punishment always is the death penalty. And the interesting thing is that as a country, we don't either have the death penalty or not. That's decided at the state level. So Michigan is not a death penalty state. So in other states that are death penalty states, it has to be a capital crime, meaning like you killed somebody. So your life will not be taken from you unless you also took somebody's life. But not all capital cases in death penalty states are death penalty cases. And there's been the only time that it's really been said that the death penalty is unconstitutional is in questions of putting minors, so under the age of actually 17, not 18, to death, or people with special needs. So in those 2 instances, a state would not be allowed to use the death penalty. Excessive fines and bail. So essentially, like, your bail has to fit the seriousness of the crime, which means that, like, if I stole a pair of shoes, my bail cannot be set at $1 million. Like, that would be silly. Now, if I committed a series of crimes and I'm deemed what's called a flight risk, then I can be held without bail, or with, kind of an exorbitant amount of bail. But it really has to do with, like, do I also have the means and the ability to, like, take my private jet and just go disappear off the face of the earth and, like, live in, the Caribbean for the rest of my life and elude federal prosecution. Okay, then they're probably going to do a higher bail on there. As I've said, this part of the 8th Amendment was just incorporated to the states February of 2019. Sorry, I did not specify there. In a case called Timms versus Indiana. And this is the guy who was arrested on drug charges, and the normal fine for a charge of that nature, a drug charge of that nature, would be $10,000. And he couldn't pay the $10,000. And so the cop seized his Land Rover, which at the time was worth $42,000. And so Tim said, that's ridiculous. Like, this is excessive. It's an excessive fine for, what you would normally give to somebody. And the police tried to argue in this case, well, we took it because it had to do with the crime. Like, he, drove to his drug deals with his Land Rover. And so it's perfectly acceptable for us to take this because it was, like, used to commit the crime. And he's like, yeah, but also it takes my kids to school. So they actually ended up, he won that aspect of that case at the Supreme Court level and got his Land Rover back. So good for Timms. 9th and 10th Amendment are not what we call justice amendments. 9th Amendment is like, hey, just because we gave you a list doesn't mean there are no other rights. And then 10th, of course, is reserved powers to states. So those are not incorporated at all, as we know, into the states because they wouldn't be really, like, tried. So the 9th Amendment has been used in court, but only within others too. All right, in here it is. So this idea of this right to privacy. So you'll hear a lot about the right to privacy. It is not actually anywhere in the Constitution, but what has been argued and upheld in court cases is that it was assumed. Okay, so in a case called Griswold versus Connecticut, 1965, a couple was doing marital counseling on the use of contraceptives, birth control, and at the time, contraception was illegal in Connecticut in any way, shape, or form. Which was, I mean, you think about like how ridiculous that is nowadays, but again, we're talking 1965. Women had a lot kind of fewer rights then that they do now. And so this couple argued, like, look, we're married and we just don't want kids. And this is kind of ridiculous that you're telling me that we can't prevent pregnancy if we want to. And so they ended up taking it to court and their lawyers argued successfully that the Constitution, while it does not state a right to privacy, explicitly, that it has a penumbras, which are zones of privacy that are implied by other things listed in the Bill of Rights, even if it never says privacy anywhere in the Constitution. So their lawyers argued that the First, the Third, the Fourth, the Fifth, the Ninth, and the 14th Amendments created the penumbra of privacy, so the zone of privacy, this right to privacy, because they said that, this idea of being free from government intrusion. So that would be on like the Third Amendment, right? Quartering of soldiers. So if you want to like take that and push it further in interpretation, you can say, well, like if you're not going to make me allow the government into my home to house soldiers in peacetime, then the government can't come into my home for any reason to survey me, right? And that is also in the Fourth Amendment, like this illegal search, illegal seizure. So this illegal government intrusion. First Amendment, of course, they would use the right to free expression. The Fifth would be due process, that clause. And then, the Ninth would be, look, individual rights also exist, even though they're not listed. And of course, the 14th then made it applicable to the states because of the equal protection clause to states. So anyway, so the First, the Third, the Fourth, the Fifth, the Ninth, and the 14th Amendments created this right to privacy. And then our final required Supreme Court case is Roe versus Wade. Probably the most famous modern case at the Supreme Court level, and also the most hotly debated, the most used by both political parties. Like you'll often hear the phrase like justices live and die by Roe. And so it's this idea, like there's always this thought that it could be overturned, or like, Democrats will say we have to save Roe, and then Republicans will say we have to overturn Roe. And so that's why like people watch the Supreme Court so closely in terms of justices, that when a justice retires or passes away, like, oh my gosh, who's in power? Like which president is there? Is the Senate of the same party? Like, are we going to turn the court conservative? Or are we going to turn the court liberal? And the thought is, if one of those happens, then a conservative court's going to overturn Roe, or a liberal court's going to keep Roe. And so, like, this case is it's like embedded in our country, and it was based off the precedent, of Griswold, which is the right to privacy. So, this was a case that originally started in Texas, and she sought to terminate her pregnancy by having an abortion. And of course, Texas law at that time prohibited abortions entirely, except if it was in order to save the pregnant woman's life. So the constitutional question here that was brought up and then through the Supreme Court case is this woman was like, well, wait a second, like, don't I have a right to do what I want with my own body? And doesn't this also apply to this penumbra of privacy that was established in Griswold? And the court at that time ruled 7-2 for Roe. And they said, yes, it absolutely is your right to decide this. And it does fall into this idea of the right to privacy. And of course, the issue that people have with this is, the main issue typically is religious, right? So you will have people that argue that, when is a fetus a person? And that's the problem with the interpretation of this case and the different interpretations of it, is that has never been, like scientifically established. It said like, a fetus is a person at conception, or a fetus is a person at 6 weeks, 20 weeks, when you hear the heartbeat, whatever. And so a lot of the people who have a very large issue with this case and with abortion being legal is because they look at it as murder. And the other side of it looks at it as not a person, not a born, a person who exists on this earth on their own right now. So no, that's not murder. A lot of states recently, and remember we talk about like when we were going to have the question on the Supreme Court case, Supreme Court comparison, and what can legislators do if they disagree with the ruling? Well, and we talk about this idea of narrowly tailoring laws, and there have not probably been more narrowly tailored laws recently meaning in like the last like 3 or 4 years, than there have been with respect to Roe. So there's a lot of states that have passed what's called heartbeat bills. And so like those are probably the most restrictive. So they've said like abortion is illegal after 6 weeks, and they're called heartbeat bills because at 6 weeks you can typically you'd be able to hear the heartbeat. The problem that supporters of Roe have is that most or a lot of women don't even know they're pregnant at 6 weeks. And so they're like, well, how can you say that that's like this, the idea of the ruling in Roe, like this last bullet point here says state laws can narrow as long as they don't cause, quote, undue burden. Well, undue burden, like how are you supposed to have that as an option if you don't even know yet that you're pregnant, number one. Number two, states have like shut down all abortion clinics except for one in the country, or all clinics that perform abortions except for one in like their entire state. And so, depending on the size of your state, like Rhode Island could probably do that just fine. But if you're in Texas and you have, one place that you could go if you need this service or you want this service, and if it's, 900 miles away from you, that would create what's called undue burden. So like this, again, this case is probably the most politicized case in maybe in all of Supreme Court history, certainly modern Supreme Court. The only one that I can think of that was, almost as or more controversial at the time that it was ruled was Brown, the Brown versus Board of Education case, which desegregated schools. So and anything that like really sort of changes like the fabric of the country is, or like, creates this idea of like progressive change, is not always necessarily the most popular. So Roe versus Wade, it is a required case. I'm surprised they made it a required case because it is so incredibly controversial. But that is the significance of this case here. In the age of terror, so the age of terror means like post 9/11. We have this weird delicate balance that the government tries to strike between security and civil rights, so national security. So we have this idea of FISA, which is Foreign Intelligence Surveillance Act, and then that established a Foreign Intelligence Surveillance Court. And that was established in 1978, and it allows for domestic surveillance. And what that means is, like, the government can put a wiretap in my house if they have enough reason to do so. Now, in order to prove enough for a FISA warrant, like you need a ton, right? So the last time that a FISA warrant was actually applied was in the 2016 election campaign, where there was a FISA warrant that was granted to surveil people having to do with the Trump campaign. Don't believe Trump himself was actually like technically the subject of the FISA warrant, but somebody who was going to be talking to him was, and so he was there were conversations and meetings that were recorded based on a FISA warrant. But you don't know when somebody has a FISA warrant on them. Like that's done at a level in like a lot of secrecy in terms of the government, because a lot of times when you're doing surveillance via a FISA warrant, it's with people who work for the government, like the U.S. government. It's not like foreign spies or anything. So that's a big deal to get a FISA warrant. And then, of course, a Patriot Act, which was re-upped latest in 2015, I believe. It might have been re-upped again in 2019. I think it's up every 4 years. But anyway, it was started in 2001 off of, on the heels of September 11th. It was put into place by George W. Bush, who was the president at that time. And what it really did was it helped lower the requirements for law enforcement officials to get warrants in cases involving terrorism. But the problem that people had, the only major problem that people had with the Patriot Act was this idea of bulk collection. And so that it ended, sorry, this keeps like coming up here. Bulk collection ended in 2015 at one of the extensions of the Patriot Act. But bulk collection was like metadata collection. So like they're listening to everybody's phone, and if they just like hear you say something, like if they hear like somebody say bomb and Taliban and whatever, all the same thing, or Al Qaeda or blah blah blah, then they're going to hear that and they're going to act on that, and they're going to surveil me a little bit further because they heard me say these like key buzzwords. So that bulk collection, for the most part, ended in 2015. But the Patriot Act does still exist, except we still have issues with, public versus private, right? So if you guys remember San Bernardino, that terrorist act in San Bernardino, California, a few years ago, and the government could not hack into the suspected terrorist's phone. It was an iPhone. And so like several different government agencies tried, and they couldn't get into it because Apple provides good security in that way. They could guess the 4-digit password. And so the FBI called Apple and said, we need you to get into this phone. And Apple very famously said, nope, we're not going to do that. And the government was very upset by this, and Apple stuck to their ground and said, we're a private company. And as soon as we open somebody's phone when the government asks us to, we lose all of our business because our customers lose their trust in us that we're not going to do the same thing for them. And the FBI is like, dude, this guy bombed places. He killed people. This is a terrorist. And Apple's like, sorry, we're not going to, like, this is a slippery slope. We're not going to head down it. So that was really interesting. At the time, people thought that Apple would really take a huge hit for that in the eyes of the public. And obviously they have not, because they continue to be probably the most successful technology company and hardware and software company, in the country. So, all right, that is finally it. Yay, we're finally done with civil liberties. How exciting. All right, I promised that was going to be short, but I think I lied. I'm really sorry. All right, thank you very much. Up next will be civil rights. So next time on EP Government.